Whenever we hear about police encounters, the general public reaction is rejoice for quick delivery of justice. So was in the case of gangster Vikas Dubey when he was killed in a police encounter. On the other hand, a lot of questions were raised about the encounter and its legal implications. So let's discuss what extrajudicial killings are. Extrajudicial killings are the killing of persons by government authorities without sanction of any judicial proceedings or due legal process. They are also known as police encounter killings or retaliatory killings. To get a better understanding, let's discuss India's most controversial encounters. In July 2020, gangster Vikas Dubey was shot dead by Special Task Force while the vehicle he was in toppled and he tried to escape. Dubey was said to have nexus with both politicians and police, thus raising questions about the police encounter's credibility. In 2019 December, Telangana police shot dead 4 men accused of gang rape and burning to death a vet. In 2016, 8 members of Student Islamic Movement of India were shot dead for allegedly escaping the jail. In 2010, more than 1500 extrajudicial killings were done by Manipur police and security force. In February 2020, 4 Manipur policemen, including an inspector, surrendered before the Imphal West Chief Judicial Magistrate in connection with the alleged fake encounters. In 2008, an information gathering exercise from the residents of the area turned into a 20-minute shootout where 2 suspected Indian Mujahideen terrorists were killed. Later on, this incident was turned into a major motion picture called Batla House. In 2006, Ram Narayan Gupta was shot dead for being an ally to gangster Chota Rajan. In 2004, Gujarat police killed Ishrat Jahan and 3 others for allegedly being operatives of Lashkar-e-Taiba. It was said that they had the plan to kill then Gujarat Chief Minister Narendra Modi. Now that we have discussed some instances of extrajudicial killings, we need to understand when does the police have right to kill. Although there are no direct provisions which empower the police officials, but there are certain enabling provisions which gives them the power to perform extrajudicial killings. One of such provision is section 46 of Criminal Procedure Code. It deals with how to make an arrest, and it specifies that the police officer may use all means necessary to effect the arrest if the person being arrested either tries to resist arrest or tries to evade it. So when we say all means necessary, does death come under one of such means for effecting the arrest? This question has also been answered under section 46, and it says that death can be caused only if the person is accused of an offence punishable with death or life imprisonment. Under section 97 of the Indian Penal Code, there is right to private defence for both body and property. And in section 100 of the Indian Penal Code, there is right of private defence to body, and it extends to causing death if the assault results in death or grievous hurt. Exception 3 to section 300 of the Indian Penal Code also comes into play, as it says that culpable homicide is not murder when a public servant is acting for the advancement of public justice and exceeds the power given to him by law and causes death by doing an act. Now, this act must be done in good faith, that what he is doing is lawful and necessary for the discharge of his duty, and without ill will towards the person whose death is caused. So, these sections supplement each other and aid in the operation of power of extrajudicial killings by the police. But the real test is determining when does the police officer exceed his powers and why is the practice of extrajudicial killing frowned upon despite providing quick justice. Well, the answer to this question is that India is a democratic country, and it believes in the principles of rule of law and natural justice, which provides for rule against bias and rule of fair hearing, as they are enshrined in our constitution under Article 14. And not just that, it further violates the Article 21 of the constitution, which provides for right to life and personal liberty, which ensures a fair criminal trial. But staged encounters make police the judge, and the procedure established by law gets sidelined. So how can we ensure that police official is not guilty or the encounter is not staged? Supreme Court in the People's Union for Civil Liberties versus State of Maharashtra laid down 16-point guideline for investigation in cases of death during police encounters. The first guideline is that the police must record any intelligence or tip-off regarding criminal activities in either written form or electronic form. Such recording need not reveal details of the suspect or the location to which the party is headed. The second guideline is that police must register FIR in case of an encounter killing in pursuance to a tip-off, and must forward the FIR to court without any delay. An independent probe by CID or police team of another police station under the supervision of a senior officer must be done, and it has to fulfill 8 minimum investigation requirements. A mandatory magisterial inquiry into all cases of encounter deaths must be held, and a report thereof must be sent to the judicial magistrate. Also, there is a need to inform the National Human Rights Commission or State Human Rights Commission, as the case may be, of the encounter deaths immediately. Medical aid is to be provided to the injured victim, and a magistrate or medical officer must record his statement along with the certificate of fitness. The investigating team must forward FIR, panchnamas, etc. to the concerned court without any delay. Once investigation has been done fully, a report must be sent to the competent court, ensuring expeditious trial. In event of death, police is supposed to inform next of kin of alleged criminal. Biannual statements of all encounter killings must be sent to the NHRC by the DGPs by a set date in a set format. If an offence under the Indian Penal Code has been committed, disciplinary action must be initiated against the police officer found guilty of the wrongful encounter, and for the time being must be suspended. Under Section 357A of the CRPC, compensation to the victim's dependent is also to be given. Also, the concerned police officer must surrender their weapons for forensic and ballistic analysis, subject to the rights mentioned under Article 20 of the Constitution. An intimation about the incident must also be sent to the police officer's family, and should the family need service of a lawyer or counseling, then same must be offered. No promotion or instant gallantry awards should be bestowed upon the officer soon after the incident. If the victim's family find that there has been a failure to follow proper investigation procedure, then in that case a complaint can be made to the sessions judge. These guidelines are also applicable to the cases of grievous injury due to police encounters. If, after following the due process, the official is found to be guilty, then he will be charged under Section 300 of IPC for culpable homicide.